U.S. Constitution calls for a national census to be conducted every 10 years. The results of the census are used to budget funds for various government programs, to determine the number of seats each state will have in the U.S. House of Representatives, and to redraw districts for state legislatures and local government bodies.
The state legislatures will take those numbers, which show you how many people are in the state and are in each area of the state, and they'll draw different maps that show different districts for the Congress members, the State House of Representative members, and the state senators. So every 10 years, those maps have to be redrawn.
Reapportionment is the process by which you determine how many seats there are to be divided up into districts. Okay? So after a general census, you reapportion. In this census, for example, Texas got 4 new seats, I believe, in the House of Representatives. So that's reapportionment. Okay? Redistricting is drawing the lines to account for those changes, because you have to add 4 seats. And conversely, for example, New Jersey lost a seat this last time, so they had to redraw their lines to account for 1 fewer representative.
In 1963, James Westbury filed a lawsuit against Georgia Governor Carl Sanders, challenging the state's apportionment plan. Because Mr. Westbury's congressional district had a population more than twice the size of other districts in the state, he claimed his right to vote had been diluted when compared to residents in other districts. The Supreme Court ruled in Mr. Westbury's favor, holding that federal congressional districts in each state had to be made up of a roughly equal number of voters. Then in 1964, the U.S. Supreme Court ruled in the case of Reynolds versus Sims. That decision applied to state legislatures, holding that members of both the state Senate and state House of Representatives be chosen from districts approximately equal in size.
The takeaway from Westbury and Reynolds is that 1 man equals 1 vote. We now say 1 person equals 1 vote, because it's no longer 1964. 1 person equals 1 vote. So if I am voting for a representative, that representative will be representing the same number of people that a representative in another district is representing. So numeric equality is the constitutional touchstone under the Equal Protection Clause of the 14th Amendment.
The Texas Constitution requires that after each census, a reapportionment plan be drawn for both the Texas House of Representatives and the Texas Senate. In 1970, the state legislature agreed on a reapportionment plan for the state's House of Representatives, but no agreement could be reached on a plan for the state Senate.
Politicians always battle over reapportionment because it can favor one party over the other, and it puts incumbents in some kind of danger because they will have shifted districts depending on how the lines are drawn by the legislature. So these things are constant battles in state legislatures.
Soon, a lawsuit was filed in a Texas district court. The lawsuit challenged the reapportionment plan that had been drawn for the Texas House of Representatives, saying it violated the Texas Constitution. The case went to the Texas Supreme Court, which agreed with the plaintiffs. Now, not only did the state legislature still have to agree on a reapportionment plan for the state Senate, but it had to design a new plan for the state House of Representatives as well. Finally, in the fall of 1971, plans for both the Texas House and Senate were announced.
There were 2 main complaints with regard to the plans. One was that there was too much population variance between the districts throughout the state. And the other was that some of the districts unfairly diluted minority voting power in Dallas and in San Antonio because they combined several House of Representatives members into multi-member districts.
What happens, say you have, let's just go with Dallas County. Say at this point in time, 45% of the residents of Dallas County were Latino or Black. If you drew up Dallas County and gave it 3 seats, there would be a chance for Latinos and Blacks to elect someone who was representative of their concerns, while whites would dominate the other races. In a multi-member district, 3 people run for office and the entire county votes. So if blacks and Hispanics voted for their preferred candidate and whites voted for their preferred candidates, all 3 of the white candidates would win. So the blacks and the Hispanics, even though they were 45% of the population, wouldn't get any representation. In a single-member district system, if you break that large district up into 3 chunks, there is greater chance that minority groups will be able to get some kind of representation in the legislature.
4 separate lawsuits were filed and were eventually consolidated into one. The lawsuits claimed that both the House and Senate reapportionment plans violated the Equal Protection Clause of the 14th Amendment.
In White v. Regester, the White that is referred to in the title of the case is Mark White, who was Secretary of State. In Texas, the Secretary of State is responsible for the administration of all the rules concerning election laws. Mr. Regester, who brought the case, was a voter of African American descent in Texas. He represented minorities who were complaining that the district lines were drawn in a way that reduced the impact of the votes of minorities.
A 3-judge panel of a U.S. District Court ruled that the plan for the Texas House was unconstitutional. The panel concluded that the multi-member districts for Dallas and Bexar counties diluted the voting strength of ethnic and racial minorities and did not provide districts approximately equal in population as the law required. The 3-judge panel upheld the plan for the state Senate.
The 3-judge district court found that there were problems with the House of Representatives plan. They found that the deviation, the differences in population between the different districts in the House plan was a problem under the Constitution. The population deviation or difference involved a maximum deviation of just under 10%. And they also found that the multi-member districts in the city of Dallas and the city of San Antonio were also a problem under the Constitution.
The court gave the Texas legislature until July 1973 to redraw the districts for the Texas House. But the ruling of the 3-judge panel was appealed directly to the U.S. Supreme Court. There were 2 questions the U.S. Supreme Court needed to resolve in the case of White versus Regester. First, were the legislative districts for the Texas House, as drawn by the state's Legislative Redistricting Board, unconstitutional because the districts varied too much in population size, therefore violating the Equal Protection Clause of the 14th Amendment? The second question was, did the multi-member Texas House districts created for Dallas and Bexar counties discriminate against ethnic or racial minorities in those counties?
The court, by a vote of 6-3, upheld the single-member districts, even though there was a variation in population. Justice White wrote for the majority that there is going to be naturally some kind of variation, especially in state reapportionments when you're talking about state legislatures, so that this didn't violate the Equal Protection Clause.
The majority ruled that the 9.9% variance between the largest and smallest Texas House districts was an acceptable variance.
The district court in this case thought that the Supreme Court's earlier cases meant that if you had any variation at all, the state had to show a really good reason for it. And the Supreme Court in the White v. Regester case said, you know, that's not quite what we meant. We think these are close enough. So the Supreme Court recognized that you're never going to have it exactly equal and you're going to have some variation.
With regard to the second question, however, the court's ruling was unanimous. All 9 justices agreed that the multi-member House districts for both Dallas and Bexar counties violated the Constitution. The justices agreed with the 3-judge district court panel that every racial or political group did not have a constitutional right to be represented in the state legislature. However, they did conclude that the multi-member districts in Dallas and Bexar counties invidiously excluded African Americans and Mexican Americans from being able to effectively participate in the election of representatives to the Texas House.
The Supreme Court was very careful to say, we're not saying that a multi-member district is always unconstitutional. They said a multi-member district can be constitutional. It depends on the circumstances. But looking at these districts, in San Antonio, where you had most of the Mexican-American population concentrated in one part of the city, they said that was too much vote dilution. The Mexican-American population, if they had a district that was just one member from the area where most of them were concentrated, they would have a more powerful voice, but when they're lumped in with the whole rest of the city, they can't have an effective vote. And a similar situation for the African-American population in Dallas.
The interesting thing about White v. Regester is that even though it is a lawsuit that happened in the early 1970s, we revisit the same questions about the fair drawing of voting districts, and we revisit the same issue of giving every vote its equal weight and its equal voice every 10 years. So the wonderful thing about it is that it's always a fresh question and a new opportunity to learn again about why we need to vote and why voting is important.